The record should be clear. I just learned about this today.
Just learned about what?
New discussion about how they want to resolve the case. To suggest that somehow this is our fault. Do you know what goes on in that conference room up there? You know what didn't happen? Them communicating with me.
I don't know what defense counsel has put on this record. It was at 8:47 p.m. last night is when he sent the email.
Defense counsel came to this hearing hot and bothered that he had to wait all morning to see the prosecutor about something that should have been handled weeks ago. That was after he was unclear about the offer they extended to his client. Turns out it was handled weeks ago, and it is this lawyer's laziness and ineptitude that threatens to cause another delay in this case. It also turns out that after this lazy lawyer emailed the prosecutor at 8:45 last night, his head enlarged and he expected Muhammad to drop everything. Or maybe his head is always like that. Judge DiSanto did have to tell him to shut up a few times. Let's roll, nerds.
Let's go on the record. Is your client here? Okay. Let's go on the record in the matter of the state of Michigan versus Bart Yenna, 221319.
Welcome to board, Mr. Yenna, present and approaching. Please state your name for the record.
Okay. So
Weeks or months.
hold on, counsel, please give me just one moment. This matter was scheduled for a probable cause conference. Is there a problem, counsel? I need to make a record. This matter was scheduled for a probable cause conference on September 4th. There was a plea to a misdemeanor, and then drug court was going to be part of the plea. Then the plea was not taken due to lack of clarity regarding the treatment court intention. And then it was adjourned to today's date at 8:30. And so I have the plea sheet here indicating could not resolve terms. So does that mean that it's going to be set for an exam?
Well, what I'm asking, Judge, is that we adjourn the matter to either the 9th or the 23rd, whatever Thursday the court may be available on those days. Because we just learned of this today. I don't know if the eligibility need for drug court is of the moment. My client's intention is to get we're going to get a independent controlled substance evaluation. He doesn't have an alcohol issue. He doesn't live in the jurisdiction. There's some details that need to be worked out. I'm not going to resolve the case and send him up for failure. And I think that what all this is talking about, which I've been suggesting, is that there needs to be an evaluation of the circumstances. The idea that he's going to sobriety court suggests he's an alcoholic or an alcohol issue. That's not the case. He's also been, and again, these are issues with the prosecutor's office. And last time we were here, the court and the prosecutor weren't sure if the offer was a kill-a-brew or a sentence agreement.
Well, the court wasn't sure because I don't know what the two of you spoke about.
I didn't know either, and I couldn't understand the language either. They didn't figure it out. They didn't clarify and say, this is what we're doing. I learned of something new today. So I don't have time to assess it and resolve the case today. I also think that whatever's being suggested here about a drug court, there's issues regarding transportation. He doesn't live in the jurisdictions. This court may take him, but he may not be able to get here. And I don't want to subject him to failure if he's not reloaded. But just even beyond, which I think is more for issue 4 when we come back. The premise seems to be that there's a unknowing desire without any reason or justification to send him to some kind of drug court counseling, missing the understanding that he's been involved in treatment and counseling for a long period of time, and he can establish that. So I don't even know if the drug court would take him, or the counseling or sobriety court would take him, because he doesn't have, at the moment, he's not in crisis, he's not, and this isn't a driving case. His use of drugs is long in his past, and he's in a program right now. So these are things that I would advocate at the time of sentencing. If there was not the court, if they weren't trying to put him in a group that he may not need to be in, and there wasn't some individualization as to which happened in this case. I'm not saying, I don't know, I'm not a doctor, but I certainly think a substance evaluation would help bring this case to resolution before we start concluding things about it. That's all. I need some more time about that. I just learned about this today. I didn't get it.
Just learned about what?
This new discussion about how they want to resolve the case.
The new discussion about how they want to resolve the case.
That's right, Judge. If you recall, yes, there was some lacking of clarity of what.
Back on September 4th,
Right, right.
she said full restitution and drug court review as part of probation. That was September 4th. So what was newly stated today that is different from, there's something different?
You want to be part of the negotiation?
No.
Okay,
No.
that's what I'm saying.
Counsel, was there something new discussed today other than treatment court?
Sobriety court, if you want to know and you want to get into as with our negotiations, well,
Counsel, I do not want to get into your negotiations.
that's what you're asking me.
No, I said, was there? I didn't ask what it was. I said, was there something more discussed today about something different than a treatment court? Whether it's drug court, sobriety court, mental health court, veterans court, they're all treatment courts. So my question is this. I don't want to know exactly what treatment court or whatever the discussion was. I'm asking is, was there something new discussed relating to treatment court? And as I indicated before, if your client resides out in Macomb County, have you looked to see, and I understand your statement and your position is that your client may not be eligible for treatment court because he doesn't have an issue with alcohol or substances. But my question is, have you contacted any of the Macomb County district courts, the treatment courts that are out there?
Not yet. That's one of the things I intend to do since I just learned of this new thing today.
Okay, so it's been 3 weeks since the last time that the parties were in court, and it doesn't seem as though there's any movement or forward progress on this matter. I will give an adjournment to October 9th, and that's the final adjournment.
Judge, respectfully, I think if we had the extra 2 weeks, it would give us the appropriate amount of time to shore up the things since you're making it a final. And again, well, we're trying to make progress. Whether we have or haven't, but the extra 2 weeks would be helpful.
Okay, counsel, let me just say this. Your client was originally here September 22nd. I don't recall if you were on the matter at that time or not. And so then the court ordered the parties to appear in court because your client had poor audio or the co-defendant had poor audio. I don't recall. And so then a warrant was issued because nobody appeared. The client didn't appear by 3:30. June 18th, the warrant was recalled. You must have walked your client in, appearance filed, and we set it for August 14th. August 14th, wait the formal reading, entered a plea of not guilty, scheduled it for a probable cause conference for August 21st. August 21st, it was held and adjourned for discovery to September 4th. September 4th, the probable cause conference was held, and that's when the plea was attempted to be taken, and there wasn't much clarity by the prosecutor's office. And so we adjourned it to today's date. Now we're here again, and there's another request for an adjournment, and you're asking for a 4-week adjournment.
Judge, with all due respect, I was at every single one of those, not the first one, but I've been here and I know exactly what happened. And to suggest that somehow this is our fault unilaterally, do you know what goes on in that conference room with there?
Hold on, counsel. Hold on. Hold on. Mr. Camorn, let me clarify something for just one moment. I'm not accusing you of anything. I'm making a record, a procedural record for the case. Because
Okay.
excuse me, let me finish. Let me finish. I understand that there is one prosecutor and multiple defense attorneys that are trying to speak to the prosecutor then. That is why this court expects that attorneys are going to speak outside of court and not wait until court to have communications. Because this court has to make sure that it is reporting accurately to the state court administrative office on our timelines. And the state court administrative office has put forth certain timelines for certain cases. This case is now over that timeline, even after your clients turned themselves in. So that counsel is why I'm making a record. I'm not accusing anybody of anything other than not having communication outside of court potentially. But that be that as it may, this court will give a 2-week adjournment.
Judge, respectfully, I just want you to hear something. The idea that you're speaking to me and I'm going to try to communicate with the other side off or outside of court happened. You know what didn't happen? Them communicating with me until I get here. Okay? This is not, I understand you're making a record, but the record should be clear. I've sent numerous emails when we're not in court. When do I get my information? Here, amongst the chaos. I had to wait till literally 11:30. I sat there for 2 hours until they told me. I said, it wasn't even sent to me. Oh, I got a response from Gary. It wasn't even sent to me. I'm not getting a response. They're sending it through him. I got to come to court. Here's it. Respectfully, Judge, I need extra 2 weeks. I'm going to get it done. I'm not asking for much. The delays or whatever it is, and your records and stuff, fine. He's out on bond. He's got his tether, which we'd like to have removed today. There's no reason for us to, and he's waived his right to speedy trial for this point, okay? So there's not a legal reason for us not to get the extra 2 weeks, all right?
All right, just 1 moment. Mr. Mohammed, you're next for the record.
Thank you. Good afternoon, Mohammed on behalf of the people. Judge, I don't know what defense counsel has put on this record. I would like an opportunity to get my phone and read the email because I don't know what he's been saying.
The request, the statement was that that there's not
When I learned about
there's not. Let me finish. Please stop interrupting me. That Mr. Comorn wants an independent substance abuse evaluation as a way to work out a resolution because he doesn't believe that his client would be eligible for treatment court based upon the representation that Mr. Yena does not have an alcohol issue or a drug issue. So that
within the jurisdiction.
I'm not done. Please stop interrupting me. Jurisdiction is not necessarily a prohibition on treatment court, counsel, as I indicated, because your client can look, you can look on behalf of your client for a treatment court that's a regional treatment court in Macomb County. That means that they would accept a transfer of somebody that lives in the area from a court in another jurisdiction. So not living in the vicinity is not a barrier to your client participating in a treatment court, if that was what was agreed upon and your client was eligible for that. Then, Mr. Mohammed, this court was making a record because the request was to adjourn this to October 9th or 23rd. And this court went through the record, the procedural record of this case as to what dates have been here and the number of adjournments that have been requested. And then that is when Mr. Comorn was questioning as to whether or not this court was accusing Mr. Comorn as to the reason why the adjournments have occurred. This court clarified that it was simply making a record. Mr. Comorn, and the court also stated that it does have an expectation that attorneys are speaking outside of court. Mr. Comorn indicated that he has sent emails to the prosecution and he just received his response today from you. So that, Mr. Comorn, would that be an accurate summary of what had occurred on the record before Mr. Mohammed walked in?
Yes, all I was asking
Okay.
was the date of the 23rd to return.
And so, and the court is not giving until the 23rd. There's been a number of adjournments. This court is not granting until October 23rd. This court is giving until October 9th. Mr. Mohammed, what is it you would like to inform the court of?
So, Judge, previously when we adjourned is because we were looking for some more clarity as to whether or not what was entailed pursuant to the drug court review. And so we did reach out to a supervisor and he responded and he indicated that
I reached out, not we.
Can we stop interrupting the record, please? You'll have an opportunity to respond, Mr. Comorn.
So defense counsel sent an email to my supervisor, and then I sent another email to my supervisor, which defense counsel was not included, which is why he does not know, because this is between colleagues. I don't need to include defense counsel in every email that I send to my colleagues. Nonetheless, I received a response to my email, and it included essentially that the defendant should be assessed by a sobriety court to determine need. If the sobriety court determines that the defendant qualifies, The defendant should be admitted as part of the sentence. The referral for the assessment is required. The sobriety court will determine whether or not there's admittance, and the defendant must be essentially honest and act in good faith with assessment. That is what the plea offer essentially is entailing, and which is not, and it's not something that I can deviate from. This is a felony case that's being reduced to a misdemeanor. It's been overlooked by supervision. I'm not in a position where I can deviate from what their intention is so that defense counsel can go get independent testing done or whatever they want to do. This is the offer. If the defense does not want to accept it, they do not have to. We will withdraw the offer and continue with a felony preliminary exam. It's very straightforward.
Now, the court's aware that I didn't want to get into the whole bringing the court into our negotiations, but thankfully, brother counsel did exactly what he probably shouldn't do. Engage the court with what we're discussing. I just wanted 4 weeks so I could get an assessment and look into the possibility of other jurisdictions. And you know what, Judge, what wasn't answered here is that, do you know when I saw what the writing was? At 12:40 or whatever it was, when he showed me on his phone. The lack of communication is not this side. It's one way. You heard he said, I'm not including the emails. The only place I would have learned of this was sitting in the third pew at 12:40 p.m. today when I learned of what it was. Asking for an adjournment under those circumstances, when they're talking about sobriety court, it's got to be these terms, sobriety court. Alcohol isn't even a thing. Judge, I would like the opportunity, Judge, to get down so that all the concerns in their offer that are now part of the court's interaction can be looked into so that when we come back, we have information, not speculation, not supposition, and we've got facts to go forward with. This is what I'm trying to do. I asked for the date because I can't guarantee that I'm going to be able to get them an assessment within 2 weeks. The people that may not be able to happen. So
Here's what we're doing. Here's what we're going to do. As I've stated before, whether it's sobriety court or drug court or mental health court, whatever treatment court it is, okay, that appears to be the intent, right? A treatment court. It doesn't have to be sobriety court as far as alcohol, because there are hybrid sobriety courts, there are hybrid drug courts, whatever it may be. This court is setting this matter for an exam on October 9th. You can either enter a plea that day or we can proceed with the exam.
Judge, if we're going to subpoena witnesses,
Counsel, we're not done.
Judge, if we're going to subpoena witnesses, I don't know if we're still going to, continue on with the plea. A plea offer has been on the table since the last hearing.
since 12:40,
It came
back in the pew.
Counsel, it was here September 4th.
Judge,
Nobody knew if it was a sense agreement or a plea or a killaboo, Judge. You didn't know, he didn't know. You'd think that they would have called and figured it out. We didn't know that. They didn't call me and say we figured out it's a sense agreement or a killaboo. Never happened. I had to communicate with the boss and still didn't get a response from him. I heard today at 12:40 in the third pew of this courtroom. The idea that what I'm asking for, I'm not working on the outside or trying to communicate with people, is a falsity.
I didn't say
Showed up here.
we weren't doing that, counsel. I said that's the expectation of the court, that attorneys are communicating outside of court.
He's certain that I'm doing that, and you shouldn't worry about me not doing that. And and with that in mind, let's look at the other side, because I'm not getting the information. I know you've got a tight schedule, but I'm doing all I can. I didn't want to show up and have to wait 5 hours to come back on another day.
and Judge,
Okay.
I have to put on the record since when he's going to go into the attempts he's making outside of court, I'm just going to go ahead and read when he sent his email, specifically what time he sent.
Because I expect.
Hold on, counsel. Mr. Kamorn, give Mr.
Last night, there's no.
Give Mr. Muhammad opportunity.
Several weeks ago.
It was at 8:47 p.m. last night is when he sent the email, and I followed it up with another email to my supervisor that same evening.
Was that, so let me ask this question. Was that the first email since September 4th?
No, on August 21st.
Since September 4th?
Right, no emails were sent by them to me.
On August,
We left here.
Was that the first email communication since September 4th?
Yes,
yeah, was the
I need
email
them.
that
Nothing from them to me.
Okay, stop. Here's what I'm going to indicate. On September 4th, there is some misunderstanding as to what the intention was, as to whether or not the sobriety treatment court was conditioned upon the plea. Meaning, if Mr. Yenna did not participate in treatment court, would the plea still continue? That is why that plea did not go forth on September 4th. Now here we are, September 25th, 3 weeks later, zero communication as to what the intent of that was until last night. So I am setting stop. I'm setting this for a preliminary examination, October 9th.
One PM.
1 p.m. In the interim, counsel, if you want to explore treatment court on behalf of your client in Macomb County where he resides, you may do so. And then if at that point on the date of exam, if your client's participating in treatment court, then the plea will continue.
Judge, I want to make it clear, there's no guarantee the plea offer will be open on the day of the exam.
Counsel, there is not any communication between the two of you for the last 3 weeks.
Judge,
I am not going to put Mr. Yenna at a disadvantage because counsel did not communicate. So I'm going to indicate that this matter is scheduled for exam October 9th at 1 p.m. There's a pending offer that has to be reviewed to whether or not Mr. Yenna would even be eligible for treatment court. If he's eligible, then we'll proceed. If not, then we won't with the plea.
His eligibility is what the assessment would make him, after an assessment, he would be a candidate for it.
Counsel, the treatment court will assess your client to determine if he's eligible. That's how that works. The treatment court does an assessment to determine if a potential participant is eligible. That's how that works.
Judge?
yes, Judge, and if the defendant qualifies, then you should enroll. That's essentially what the plea is. It's very clear.
Have you spoken to your client about treatment court?
Yes, we have, and we intended to come back on another day after we had assessment and information was gathered about Macomb County liabilities. That was the intention of the adjournment.
Okay, well, when you come back for the exam, you'll know if there's availabilities and if your client's eligible. I'm not going out to October 23rd.
All right. Will the court consider removing his tether since he has had no incidents, shows up to court, and has been in complete compliance with it? It's costing $70 a week, I understand. And while he's doing a lot of community service in the neighborhood for other people, his limited employment, if parents essentially don't have to contribute to that. I don't know if it's necessary at this point. He's in a treatment program. He's had no incidents of any relapses. He's counseling. He takes urine screens regularly with no negatives or positives, I should say. And as far as concerned of his return to court, I think at virtually being here regularly in the current situations in concerns would be alleviated. I know he didn't show up originally from his Zoom or whatnot, but that was 2021. And he lives with his father who's here. His insurance returned to court. If he needed a second, if he needs someone else to attest to his sobriety, I'd ask the court to consider removing the tether and keep all these other conditions in place.
And Judge, before we get into that, I just again want to make it clear for the record that the plea offer in this case was extended on August 21st. We've had ample enough time for defense counsel to, speak to his client. He knew our intention at that time. Whether or not it was a sentence agreement, that was a question that I needed some more clarity on. I think my supervisors made it clear. If I'm going to relay everything that's transpired today, if he comes back and he does not want this plea on the table, I want to make it clear that I would be withdrawing the plea offer. So I just want to provide clarity for the court and the record that there is no guarantee that this will be open on the day of the exam.
Okay?
It's been open since August 21st.
Look at it.
Record made. The court will indicate that based upon the number of times that this matter has been adjourned and Mr. Yen has been present at all of those court dates since he walked in on the warrant on June 18th, the court will remove the tether. We'll see you all back on October 9th, witness and exhibit list by October 6th. Thank you. Have a good day.